Did you know that often when you receive a green card through marriage, it has conditions on it? That means that the card and your permission to stay in the United States is not permanent, it's a temporary green card. The applicant, aka you, the beneficiary, must wait a certain amount of time before you can apply to remove these conditions. When that time is up, you must apply for a permanent green card or risk being deported. Once you go through another application process and are approved, you receive a permanent green card. Tonight, I'm going to talk about what a conditional green card is. I'm going to explain what you must do to have the conditions removed and when you must do that. I'm also going to share with you what evidence you will need to submit with your application. And I'll explain what you must avoid if you don't want to be denied.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
What is the conditional green card? Most green cards are for 10 years before you must renew them. However, if one, you got your green card through marriage, and two, your marriage is less than 2 years when you got your green card, you would be issued the conditional green card for 2 years. 90 days before the 2-year anniversary, you will need to file a petition to remove conditions on residence known as Form I-751. That's Form I-751 in order to get your permanent green card. If you are an entrepreneur and obtained your green card through investment, you would need to file a different form. It's I-829. But think of it like probation. Before the probationary period ends, you must fill out more paperwork and likely today have another interview. Historically, it didn't require an interview always, but under Trump, well, everything's taking a lot longer. Bottom line is, immigration believes that every petition is fraudulent and it is your job to prove it is real. Immigration believes that a marriage of short duration is more likely to be fraudulent, so they make you go through this additional step. How do I know if I have a conditional green card? So how can you check to see if you have a conditional green card versus the permanent green card? Well, the first and easiest is to take a look at the front of your green card. It will say at the bottom middle, valid from and card expires. If it's only good for 2 years, congratulations, you have a conditional green card. Second, right above that, it says the word category. If under category it says CR1, once again, it's a conditional green card. What are the basic requirements? Well, generally, you need to apply to remove conditions on your green card if, one, you are still married to the same spouse that got your green card 2 years ago. Now, you can include your kids if they receive their conditional status either at the same time or within 90 days as you did. So either they filed it with you or within 90 days of when you got it. Or that's one scenario. Another scenario is if you are a child and for a valid reason, you couldn't be included in your parents' application. Third, your spouse died and you entered your marriage in good faith. Fourth, you entered a marriage in good faith, but the marriage ended through divorce or annulment. And 5, you entered the marriage in good faith, but either you or your child were battered or subject to extreme hardship by your U.S. citizen or permanent resident spouse. Now, in any one of those 5 scenarios, you can file to remove the conditions on your green card. Obviously, assuming you have a conditional green card. If you have a permanent green card, that doesn't apply to you. Mistakes to avoid. Today, if immigration denies your Form I-751, they will send you a letter explaining their decision. They will also include what's called a notice to appear in immigration court. That puts you into removal proceedings. You really want to avoid that. Now, not enough evidence of a bona fide marriage. Okay, so let's take a step back. If you make a mistake and your petition gets denied, you get put into removal proceedings. That is a scenario you definitely want to avoid. Now, what are some common mistakes? Well, not providing enough evidence of a bona fide marriage. Just like when you filed for your green card, you must prove that you have a legitimate marriage. You can't just submit a marriage certificate and expect it will be enough. On the same token, you can't just submit the same documents you provided 2 years before and expect it would be enough. So what we tell our clients is, listen, I'm a storyteller. I tell your story from how you went to hello, to I want to live the rest of my life with you, to I'm living with you and married to you, and then 2 years later, I'm still together. So we continue that story. So the documents that you filed when you initially got your green card, yes, of course, some of it are necessary, like birth certificate, citizenship documents, things of that nature. But you got to show what's happened in the past 2 years. You provide the same type of documents. So the marriage certificate by itself is not enough. And hey, just saying I'm still together, that's not enough too. You got to do more than that, particularly today. So examples are birth certificates of any children born to the marriage. Again, and this is typically in the past 2 years. Evidence of shared finances like bank accounts, credit cards, car insurance, medical insurance, gyms, medical insurance, and wills. Evidence that you live together like a lease or a mortgage, utility bills, even junk mail. When you live at an address long enough, you're going to start getting junk mail. Believe me, you can have all of mine if you want. Evidence of life together, like photos, vacations, time with each other's family, letters from family and friends that know the two of you as a couple. Now, that's the evidence that you're going to need with your submission. If you don't provide enough of it, you're going to get denied and you're going to get put into removal proceedings. Similarly, if you file late or you don't file at all, guess what? You're going to get a notice to appear and you're going to be put into removal proceedings. If you file late, immigration could also put you into removal proceedings. So my point is, you have 2 years from the date you got your green card to file. If you file a day too late, immigration theoretically could put you right into removal. They don't typically move that fast, but they could, so don't give them the opportunity. Now, another thing to avoid, so again, not filing, not submitting enough information, filing late, those are mistakes. Another one is criminal conduct. You've done the hard work of getting your green card. Don't lose it now by pleading guilty or being found guilty of a serious crime. Don't let the 2 years pass by without filing. No matter what happens, don't let the time pass. It's a real problem because, again, immigration will put you into removal proceedings. So thank you for joining us. I'm Andres Mejer. Until next time.